Hello everyone, my name is Roma Jessa V. Madaloso. So today we're going to discuss the fourth pillar of criminal justice system, which is the correction. So what is correction? Correction is a branch of criminal justice system which concerned of custody, supervision, rehabilitation of criminal offenders. So correction is focuses on a person who commit a crime in putting into jail or in the prison in order for them to reform, change, grow, for them in the future will go back to the society again. Next is examples of correction. So first one is incarceration. Incarceration is confinement of jail or in prison. Next is the parole. Parole is a release of a person from correctional institution after being serving minimum period of prison sentence. Next is the probation. Probation is also a release of a person but without any serving a prison sentence. So what is the difference between the parole and the probation? So probation is a decision of a judge after being the accused is um, found guilty. So the judge will decide if instead of the jail or in prison, they grant probation to the accused, but there were a restriction in outside of the community. May nagbabantay pa rin sa'yo sa labas kung anong ginagawa mo, kung nagfa-follow ka ba rin pala ng mga rules. So, ang parole is also a decision of a, not a judge, but a decision of a parole commissioner. So, you have a chance to get a parole if you prove to the parole commissioner if you are really not a threat in the society. So if they prove if you prove that you are not um, a threat in the society, so they will grant a parole for you to out early in the prison. Next, punishment. So punishment is infliction of some kind of pain and loss, and punishment is also consequences of your actions. So in relation to criminal justice system of punishment, uh, punishment is reform, improve, rehabilitate, and imposition of a penalty. Next, theories of punishment. So there are two theories of punishment. First one is the utilitarian theory and the retributive theory. So utilitarian theory discourage future wrongdoing. So ang utilitarian theory is example, nag-commit ka ng crime and then when you commit a crime, pag makalabas ka na dyan sa prison is of course ang purpose nitong utilitarian theory, ang theory nito is after you makalabas ka na is of course 'di ba hindi mo na uulitin yung ginawa mo na crime kasi alam mo na yung punishment mo if ginawa mo yan. So yan yung utilitarian theory. I-discourage future wrongdoing. Next is the retributive theory. Punish offenders because they deserve to be punished. So ang theory nito is if mag-commit ka ng crime is you really deserve to be punished. Just like I remember with my childhood, I punched my sister and then so nag-commit ako ng but not literally a crime but nag-commit ako ng bad doing kaya I need to be punished by my father. So just like the in the law, if you commit a crime in the society, so you need to be punished. You are deserved to be punished of your doings, your consequences of your action. You need to be punished. Next, deterrence. Deterrence is under the utilitarian theory. So deterrence, there are two types of level: the specific level and the general level. So the specific level is prevent the same person from committing crimes. So example of this is um, si Juan de la Cruz is he commit a crime, and then inside the correctional institution he realized that if he will go out, kung nakalabas na siya dito, hindi niya uulitin yung crime na ginawa niya or yung bad na ginawa niya sa society kasi alam niya na ng punishment niya. So ito yung specific level. Maybe put in jail. Incapacitation is designed to be unpleasant. So next is the general level. Prevent other people from committing crimes. Example, Juan de la Cruz. Friend mo si Juan de la Cruz, and then nakita mo na kinulong siya dahil may ginawa siyang mali sa society. Kumuha siya ng pera sa cashier sa mall. So na-sentence siya ng 2 years, example, 2 years. And then, pag nakalabas na siya o kaya habang nasa sa loob, yung friend mo, na-realize mo na ganun pala yun. Pag magkumuha ka ng pera sa mall, tapos ma-sentence ka ng 2 years, syempre, hindi mo na uulitin kasi, hindi mo na, hindi mo gagawin yung same na ginawa mo kay Juan de la Cruz dahil alam mo kung ano ang consequences nito. So this is the general level to prevent other people from committing crimes. Serve as an example to the society. So yung ang friend mo nag-serve siya ng example ng society na ito ang consequences if gawin niyo to. So syempre, it also prevent to other people para mag-commit and crime. Next is penology. So penology is a punishment for criminals. So it's obvious. Next, concept of penology. We have we all know that the concept of penology is the punishment of criminals, but penology is not also all about punishment of criminals, but also the community service, probation orders, guidance, aftercare. Oh yeah, that's all. So that all is my report. Thank you.
Good day everyone, this is my report and here is my topic. Chapter 22, Present Correctional Setup in the Philippines. A. Philippine Correctional Setup. B. Classification of Prisoners. Section 1, the Bureau of Corrections. A. Organizational structure. B. Mandates. C. Transfer of national prisoners after conviction mandatory even if judgment is still on appeal. D. Modification of Circular Number 492A on the transfer of national prisoners to the Bureau of Corrections in Muntinlupa, Metro Manila. Philippine Correctional Setup. The present setup of correctional system in RP is managed and controlled by four different agencies of the government. They are: number 1, Bureau of Corrections; number 2, Provincial Government; number 3, the Bureau of Jail Management and Penology; and 4th, the Bureau of Child and Youth Welfare. B. Classification of prisoners. Prisoners are classified as follows according to their sentences, and place of commitment. Number 1, national prisoners. These prisoners who are sentenced to imprisonment of more than 3 years. Number 2, city or provincial prisoners. These are prisoners sentenced to imprisonment of more than 1 year but not more than 3 years. Number 3, municipal prisoners. These are prisoners sentenced to imprisonment of not more than 1 year and shall be committed to the municipal jail warden. Supreme Court Circular Number 4293, dated August 27, 1993. Section 1. The Bureau of Corrections. A. Organizational structure. This agency is attached to the Department of Justice and charged and houses national offenders sentenced to serve prison terms of more than 3 years. This agency has 7 operating penal prisons farm operating nationwide. Number 1, the Correctional Institution for Women, CIW, in Mandaluyong City. This facility houses all national female prisoners. Number 2, Iwahig Prison and Penal Farm in Puerto Princesa City, Palawan. This facility houses a national prisoners in Palawan and Puerto Princesa. Number 3, Sablayan Prison and Penal Farm in Occidental Mindoro. This facility houses national prisoners in Mindoro Oriental and Mindoro Occidental. Number 4, San Ramon Prison and Penal Farm in Zamboanga City. This facility houses national prisoners in Region 9 and 12. 5. Leyte Regional Prison in Abuyog, Leyte. This facility houses national prisoners in Region 8. 6. Davao Prison and Penal Farm in Panabo, Davao Province. This facility houses national prisoners in Region 10 and Region 11. Number 7, the New Bilibid Prison in Muntinlupa City. This facility is charged with custody and rehabilitation of all other national male prisoners not included in the foregoing enumeration. B. Mandates. To carry out its mandates, the Bureau undertakes the following. First is confine persons convicted by the courts to serve a sentence in national prisons. Number 2, keep prisoners from committing crimes while in custody. Number 3, provide human treatment by supplying the inmates basic needs and implementing a variety of rehabilitation programs designed to change their pattern of criminal or antisocial behavior. And fourth, engage in agro-industrial projects for the purpose of developing prison lands and resources into productive bases of profit centers. C. Transfer of national prisoners after conviction mandatory even if judgment is still on appeal. The transfer of national prisoners to the National Penitentiary to Muntinlupa is provided for in Circular Number 492A. The circular was the court's response to the problem that some judges refused to issue mitimuses for the transfer of prisoners sentenced to imprisonment for more than 3 years to the Bureau of Correction in Muntinlupa, Metro Manila, for the reason that their cases are on appeal. Under the circular, judges are required to immediately issue orders of commitment only after the conviction of national prisoners. D. Modification of Circular Number 492A and on the transfer of national prisoners to the Bureau of Corrections in Muntinlupa, Metro Manila. Clarification has been sought by concerned judges regarding their authority to allow the commitment of national prisoners to national penal institutions other than the main national penitentiary to the city of Muntinlupa, considering that Circular Number 492A, which directs all trial judges to issue commitment orders of national prisoners immediately after their conviction, mentions only the penitentiary in Muntinlupa as the institution to which these prisoners should be transferred. In the Department of Justice Circular Number 4 of January 15, 1991, the Secretary of Justice directed provincial and city prosecutors to file with the proper court immediately after the promulgation of the judgment convicting a national prisoner a manifestation requesting said court to commit the prisoner directly to the national penal institutions mentioned in the circular. These are number 1, national prisoners in Region 10 and 11 to be committed to the Davao Prison and Penal Farm in Panavo, Davao del Norte. Number 2, national prisoners in Region 9 and 12 to be committed to the San Ramon Prison and Penal Farm at Zamboanga City, Zamboanga del Sur. Number 3, national prisoners in Region 7 to be committed to the Leyte Regional Prison in Abuyog, Leyte. Number 4, national prisoners in Palawan and Puerto Princesa City to be committed to the Iwahig Prison Penal Farm in Puerto Princesa, Palawan. And number 5, national prisoners in Mindoro Oriental and Mindoro Occidental to be committed to the Sablayan Mindoro Occidental. The purpose of Circular Number 492A, which are the Congress, provincial, city, and municipal jails and effect better control supervision over national prisoners are still served if these prisoners and transferred to the mentioned national penal institutions. Accordingly, the judges concerned may, in the exercise of sound discretion, favorably act on the manifestation of prosecutors for direct commitment of national prisoners to this penal institution. So, it is understood that all female national prisoners shall continue to be committed at the Correctional Institution for Women in Mandaluyong, Metro Manila, and other national male prisoners not included in the foregoing enumeration shall be committed to the new Bilibid prison in Muntinlupa City, Circular Number 6397 in October 6, 1997. So that's all, and thank you.
Section 2. The Provincial Government. The Provincial Government. A provincial government is autonomous of other provinces within the Republic. Each province is governed by two main elected branches of the government. Executive, led by the governor, assisted by vice-governor, and legislative, consists of provincial board members depending on how many districts the province composes of, but usually in a district there are 4 board members. Judicial affairs are separated from provincial governance and are administered by the Supreme Court of the Philippines. Two main elected branches of the government. Executive, composed of President, Vice President, Cabinet, local government. All executive departments, bureaus, and agencies are under the jurisdiction of the President of the Philippines. This comprises reorganization, reconfiguration, and the appointment of officials. The President is also accountable for the above-mentioned offices' strict adherence to the law, according to the Administrative Code. Legislative consists of Senate and the House of Representatives or Congress. It has the power to create legislation, confirm or reject presidential nominations, and declare war. Congress, or the Senate of the House of Representatives, and various agencies that provide support services to Congress make up this branch. Section 3. The Bureau of Jail Management and Penology. The Bureau of Jail Management and Penology is an attached agency of the Department of the Interior and Local Government, mandated to direct, supervise, and control the administration and operation of all district, city, and municipal jails in the Philippines, with pronged tasks of safekeeping and development of its inmates, officially classed as person deprived of liberty or PDL.
Child Youth Welfare of the or DSWD, Department of Social and Welfare Development. Outstanding feature of RA 9344, minimum age of criminal responsibility. Article 12.3 of the Revised Penal Code amended. Intervention program of child in conflict with law. Presumption minority. The minimum age of criminal responsibility. The minimum age of criminal responsibility has now been increased to 15 years of age. Section 6 of RE 9344, otherwise known as Act of Establishing a Comprehensive Juvenile Justice and Welfare System, provides that a child 15 years and under at the time of commission of the offense shall be exempt from the criminal liability. A child 15 years but below 18 years of age shall likewise be exempt from criminal liability and be subjected to an intervention program unless he she has act with discernment, in which case such child should be subjected to the appropriate proceeding in accordance with this act. The exemption from criminal liability herein established does not include exemption from civil liability, which shall be enforced in accordance with existing law. Ang minimum nga edad sa criminal liability is 15, but kini nagpasabot nga kadtong edad o kung edad o 15 to 18 years of age, mahimong mapriso sila sa mga youth centers o sa mga rehabilitation program, sabtang kadtong 15 below is exempted sila sa criminal liability. The reason for the exemption is that a minor of such age is presumed lacking of the mental element of a crime, the capacity to know what is wrong as distinguished from what is right, or the determine of morality of human acts wrong in sense in which the term is used is morally wrong. And Jose versus Nazario, GR number 162052, January 13, 2005. The reason for the exemption of minor, because the minor is wala pa sila na aware sa mga other crimes, or wala pa sila na aware sa mga rules sa batas. Article 12.3 of the Revised Penal Code of amended. Prior to the passage of RA 9344, the issue of minor of offender affecting his or criminality depends on what bracket he/she is at the time of the commission of offense. If the offender is within the bracket of 9 years and below, the said minors is absolutely exempted from criminal liability, regardless of whether he/she act with discernment, If the offender is within the bracket of 9 years and below 15, he she is still exempted from criminal liability unless he she act with discernment. If the offender within bracket of 15 years and below 18, then the minor is no longer from criminal liability regardless of whether he act with discernment. Kung nag-ida, kung ang edad is o 9 years below, absolutely exempted sila sa criminal liability. Regardless lang gyapon sa act with discernment. And kung nakabracket sa 9 years of below 15, uh, still exempted gyapon sila sa criminal liability. Then sa kung nakabracket ka sa 15 to 18 below, there is no longer exempted from criminal liability regardless of whether the act with discernment. The new law now is as embodied under Section 6 of RA 9344 amends the aforementioned article of the revised penal code. The age bracket now has been extended to 9 to 15 years of age. Within this bracket, the child absolutely exempted from criminal liability. The second bracket is from 15 to 15 below 18 years of age. Likewise, a child whose age is within this bracket at the time of the commission of the offense is still exempted from criminal liability unless he act with discernment, in which case he is criminally liable. Intervention program of child in conflict with law. A child in conflict in law shall be subjected to an intervention program that is after termination of the age of under custody. Ang child, if a child is makakalabag sa batas, dapat sila moagi sa or mapasilalim sa mga intervention program o iniguman sa pag-determine sa age of the child under custody. The authority who has initial contact with the child shall be immediately released and her to the custody of her parents or guardian in the absence thereof the nearest relative. If the parents, guardians, or nearest relative cannot be located or he refuse to take custody, if a child may be released to any of the following. If no guardians na or parents na mo release mo or mo locate, if dili sila man-locate, release sila sa one, a duly registered non-governmental or religious organization, barangay official or member of the barangay council for the protection children BCBC. 3, a local social welfare and development officer, or 4, when and where appropriate to the DBCLD. Dili sila gina-release pag walay molukit sa custody. Dili ginadala ang mga child if walay mo release ay walay mo locate. If the child referred to herein has been found by the local social welfare development office to be abandoned, neglected, or abused by his parents, or in the event of department will not comply with prevention program, the proper petition for involuntary commitment shall be filed by DSBWD or the local social welfare and development office pursuant to presidential decree number 603, otherwise known as Child and Youth Youth Welfare Code, Section 20 RA 9344. Presumption of minority. The child in conflict with the law shall be enjoy the presumption of minority, shall enjoy the rights and privilege accorded by law until proven to be 18 years of age. The age of a child may be determined from the child's birth certificate, baptismal certificate, or any others pertinent documents. In the absence of these documents, age may be based on information from the child himself, herself, testimonies of other persons, the physical appearance of the child, and other relevant evidence. In case of the as to the age of the child, it shall be resolved in his or her favor, Section 7 RA 9344. Yun lang po ma'am, that's all, thank you.
Good day, ma'am. I am Melvin Malangit. Now, I will continue the report of Glenford John Maldo. The topic is extinction of criminal liability. Criminal liabilities may be partially or totally extinguished. Article 90. Prescribe of crime. Crime punishable by death, reclusion perpetua, or reclusion temporal shall be prescribed in 20 years. So, if you have a committed crime by punishable by reclusion perpetua or reclusion temporal shall be prescribed in 20 years. So, you have prescribed 20 years imprisonment by punishable or offense, either penalty. The crime punishable by other afflicted penalty should be prescribed in 15 years. So in other penalties is prescribed in 15 years on imprisonment. Those punishable by a correctional penalties should be prescribed in 10 years with the exemption of those punishable by aristo maior, which should prescribe in 5 years. So the correctional penalties, prison, correction, aristo maior, suspension, desterrolize penalties, aristo minor, public serious penalties, common to the three preceding classes, fine and ban, to keep the peace. So aristo maior or the correctional penalties, the aristo maior, the duration of the penalties of aristo maior should be from 1 month and 1 day to 6 months on imprisonment. In aristo minor, the duration of the penalties of the aristo minor should be from 1 day to 30 days, ban to keep the peace. The crime of libel or other similar offenses should be prescribed in 1 year. So, pinakamababang kaso or mababang kaso na yung you have committed a lower crime, that is the 1 year penalty or 1 year imprisonment. The crime oral duration and slander by deed should prescribe in 6 months. The oral duration and slander by deed should be punished by arresto minor in its minimum period to prison correctional. In its minimum period, it is not or is it is of a serious and insulting nature. Otherwise, the penalty should be arresto minor or fine not exceeding 200 pesos. In Article 355, legal means of writing or similar means. Light offenses prescribed in 2 months. So that is the pinakamababang kaso na iyong ginagawa. That is the penalty of 2 months imprisonment. In Article 90, when the penalty fixed by law is compound, one the highest penalty should be made the basis of the application of the rules contained in the first, second, and third paragraphs of this article. The whole topic of this article is about the penalties of the imprisonment, about the reclusion perpetua, of the offenses of the person who committed a crime. And this is the end of my report. Thank you.
Hello guys, hello everyone. I am Glenford John Maldo, and we will now talking about the extinction of criminal liability. So what is criminal liability? So in simplest term, when you are criminal liable, it means you may be held legally responsible for breaking the law. And the extinction or the total extinction means that the entire penalty is extinguished or mawawala, and there is no more criminal liability. So criminal liability may be partially or totally extinguished, but now we will be talking about only totally extinguished. So how criminal liability is totally extinguished? So criminal liability is totally extinguished first when by the death of the convict. As to the personal penalties and as to the pecuniary penalties, liability therefore is extinguished only when the death of the offender occurs before the final judgment. So for example, if the convict died before his final judgment, his or her penalties and criminal liability will be extinguished, or lahat yun mawawala if ang offender ay mamamatay. Next is the by service of the sentence, means that they have served their liability. So for example, if the offender already served his sentence within jail or prison, then his or criminal liability will be extinguished or mawawala. Number 3, by amnesty, which completely extinguish the penalty and all its effect. So what is amnesty? So amnesty is the act of releasing or protecting a person from prosecution from wrongdoings. So an example of amnesty is when a criminal is told to go free by the president or by the authorities. Next is by absolute pardon. So what is absolute pardon? It is the total extinction of the criminal liability of the individual to whom it is granted without any condition whatsoever, resulting to the full restoration of his civil rights. So the example of the absolute pardon is, for example, if the convict receive an absolute pardon by the president, so his or her criminal liability will be extinguished. Next is by the by prescription of crime. So prescription of crime happens wherein the state loses the power to prosecute. And we have here the by prescription of penalty. So just like the prescription of the crime, this happens when the state loses the power to impose penalty. So if the state loses his power to impose penalty and loses power to prosecute, then the criminal liability of the convict will be extinguished. And the last one we have here by the marriage of the offended woman as provided in Article 344 of this code. So for example, in any case of rape, yung offender, pinakasalan niya yung offended woman, tapos pumayag naman yung offended woman o yung na-rape na panagutan siya at pakakasalan siya, maaaring mawawala yung criminal liability nung offender. Mawawala yung kanyang criminal liability. So that's all. Thank you. Thank you for listening, guys.
Good day, ma'am. I'm Angelo Nino Poral. For this video, I will be discussing about the community corrections. So first is, what is corrections or correction? So as we know, correction is a part of the Philippine criminal justice system. So in this video, so how we define community corrections. So community correction is also known as the community-based corrections community. So it refers to a wide range of sentences that depend on correctional resources available in the community. It does also permit convicted offenders to remain in the community under conditional supervision as an alternative to an active prison sentence. So community corrections, definition and scope. So community corrections is sometimes referred to as non-institutional corrections. So community corrections also the subfield of corrections in which offenders are supervised and provide service outside jail or prison. So after the person who is convicted in the court, he will be undergo in the jail and conduct some rehabilitation based on the community corrections rule. Goals and staff rules. Community corrections traditionally emphasize rehabilitation as its goal. So as what I mentioned earlier, the community correction is the main goal is to rehabilitate the convicted. So one of the example of community corrections is we have the probation, parole, work release. In its purpose of community corrections, there are major goals and objectives of community correction programs. First is to reduce prison populations, to protect public, that is provide public safety. Number 3, to keep offenders under supervision in the community. Number 4, to reduce offender recidivism, and last is to generate cost savings. So goals and staff roles. The staff of the community correctional programs have two potential competing roles that reflect different goals. First is seeing the offenders comply with other orders of community sentences, helping offenders identify and address their problems and needs. So for this last slide, so as what you see, this is a cycle, or what we call this is the vision and mission of community corrections. So as what we see, we have the it is the mission of Tri-County Community Correction to aid victim recovery by humanly detaining, supervising, and facilitating rehabilitation of those who have violated the peace and prosperity of our communities. And that's all. Thank you.
Hello everyone, my name is Michael Jan Orito and I'm going to discuss about the provision, which is a community-based program or correction. So provision are established under Presidential Decree number 968 on July 24, 1976 by former President Ferdinand E. Marcos, wherein establishing a probation system, appropriating funds therefore and for other purposes, and it is also known as a probation law. Probation defined. Probation is a disposition under which a defendant, after conviction and sentence, is released subject to conditions imposed by the court into the supervision of a probation officer. So probation is a grant for the uh, convicted person of the trial court, and they will still remain in the community, but subject to the conditions that given by the court, and they will supervised by under the probation officer. Nature of order granting probation. Probation is a mere privilege, and its grants rest upon the discretion of the court. Even if a convicted person is not included in the list of offenders disqualified from the benefits of the decree, the grant of probation is nevertheless not automatic or ministerial. The court should, before granting probation, consider the potentiality of the offender to reform, together with the demands of justice and public interest, along with other relevant circumstances. So even if the offender or convicted person is not disqualified under the benefits of the decree, they will there are many certain things that should consider or looking for, especially their potentiality to reform, and also uh, the demands of justice and the public interest before they will give the benefit of probation to the offender. Purpose of probation: promote the correction and rehabilitation of an offender by providing him with individualized treatment. So one of the purpose of the probation is to provide an individualized treatment, which is like psychotherapy, counseling, and any other necessary program that necessary to them, to especially to change their views in life or philosophy. And second is provide an opportunity for the reformation of a penitent offender, which might be less probable if he were to serve and prison sentence. So it is a privilege to them to have a grant of probation, because they will still remain in the community, and they will just follow the conditions that given the court to them, and it will be less probable if they were to serve their sentence to the jail or prison. And third is prevent the commission of offenses. So if the person is uh, given the individualized treatment, so it will change the views in life and their philosophy, as well as their nature of committing the crime. It will change, so it will prevent the commission of offenses or crime. Criteria for placing an offender on probation. In determining whether an offender may be placed on probation, the court shall consider all information relative to the character, antecedents, environment, mental and physical condition of the offender, and available institutional and community resources. So, the court shall need relevant information about the offender, especially the character, antecedents, environment, mental and physical condition of the offender. So, Probation shall be denied if the court finds that. So first is the offender is in need of correctional treatment that can be provided most effectively by his commitment to an institution. So if the offender is in need of a correctional treatment, like they have a serious illnesses that the program is in place on the institutional program, so the court shall be denied them to be granted with the probation because they will need in place in the institution correction or program. And second, there is undue risk that during the period of probation, the offender will commit another crime. So if they will find out that, especially uh, the mental condition of the offender, and they have the uh, what we call this one, they will sense that this particular person, if they will place into the probation period, will commit another crime, and it will not be, and the offender will be not be trusted. And third is probation will depreciate the seriousness of offense committed. So if they will find out the seriousness of the crime, so the court will be denied the grant of probation to the offender. Who cannot avail of probation? First is those sentenced to serve a maximum term of imprisonment of more than 6 years. So those who have imprisonment of exceeding 6 years of imprisonment, they will cannot avail the probation. Second is those convicted of any offense against the security of the state. So if that particular person is committing a crime against the security of the state, they will cannot avail the probation. Third is those who have been previously been convicted by final judgment of an offense punished by imprisonment of not less than 1 month and 1 day, or a fine of not less than 200 pesos. So if that particular person have an history or previously served a sentence of not uh, not less than 1 month and a 200 pesos of fine, they will cannot avail the probation. Fourth is those who have been once on probation under the provisions of the decree. So if that particular person has been in probation before and they commit another crime, they will cannot avail a second probation grantees. And five is those who are already serving sentence at the time that substantive probation of the decree became applicable pursuant to section 33. So uh, that's it. That is the following of the uh, list of the an offender that cannot avail the grant of the probation. Classification of conditions that may be imposed against a probationer. The conditions which trial courts may impose on a probationer may be classified into general or mandatory, special or discretionary. So in general or mandatory conditions, the probationer should present himself to the probation officer designated to undertake his supervision at such place as may be specified in the order within 72 hours from the receipt of said order. So if the probationer received his order of the probation, so they will need present themselves to the said officer within 72 hours and report to the probation officer at least once a month, such time and place as specified by said officer. So the probationer should be present themselves at the said officer at least once a month. So in special or discretionary conditions, cooperate with a program of supervision, meet his family responsibilities, devote himself to a specific employment and not to change said employment without the prior written approval of the probation officer, undergo medical, psychological, or psychiatric examination and treatment, and enter and remain in a specified institution when required for that purpose, and pursue or prescribe secular study or vocational training, attend or reside in a facility established for instruction, recreation or residence of persons on probation, refrain from visiting houses of ill repute, abstain from drinking intoxicating beverages to excess, permit a probation officer or an authorized social worker to visit his home and place of work, reside at premises approved by it and not to change his residence without its prior written approval, or satisfy any other condition related to the rehabilitation of the defendant and not unduly restrictive of his liberty or incompatible with his freedom of conscience. So that is the following list of the special or discretionary conditions uh, that may be imposed to the probationer. So, effect of violation of conditions of order of probation. So, non-compliance of conditions of the order of probation shall cause for the issuance of a warrant of arrest against the probationer. If the violation is established, the court may revoke or continue his probation and modify the conditions thereof. If revoked, the court shall order the probationer to serve the sentence originally imposed. An order revoking the grant of probation or modifying the terms and conditions thereof shall not be appealable. So, if the probationer is violating certain conditions of the court, will be lead them to issued a warrant of arrest for them, or the court will be um, revoke or modify the certain conditions for them. But if it is already revoked or modified, it will not appealable anymore. So the probationer needs to be follow follow all the conditions that given to them by the court. And thank you everyone, and hopefully you understand what I have discussed. And God bless everyone and stay safe.
Hello everyone, good day. So this is Ramilin Tiwa Panay, and for today's discussions, I am the one who tasked to discuss this topic, the parole, or the legal environment surrounding the application of parole and its significant cases decided by the Supreme Court. So what exactly does parole mean? So parole defined, it refers to the conditional release of an offender from a correctional institutions after he has served the minimum of his prison sentence. It means that the release of a prisoner temporarily for a special purpose or permanently before the completion of a sentence on the promise of a good behavior and he committed a burglary while on a parole. Okay, next, nature of grant. Nature of grant, it is a prisoner may be granted parole whenever the board finds that there is a reasonable probability that if released, he will be law-abiding and that is release will not be incompatible with the interest and the welfare of society. Next, next is the goal of parole. And the goal of parole is to do the following. First, uplift and redeem valuable human material to economic usefulness. And lastly, to prevent unnecessary and excessive deprivations of personal liberty, or to avoid unnecessarily and excessively restricting personal liberty. Next, who cannot avail. So the following prisoners shall not be granted the parole. First, if those convicted to offense punished with death penalty, reclusions perpetua of life imprisonment. The second, those who convict of treason, conspiracy, or proposal to commit treason or espionage. Those convicted of misprision of treason, rebellion, sedition. 4. Those convicted of piracy or mutiny on the high seas of Philippine waters. Number 5, those who are habitual delinquents, those who, within a period of 10 years from the date of release from prison or last convictions of the crime of serious or less serious physical injuries, robbery, theft, srafa, and falsification, are found guilty of any of said crime and a third time of offender. Number 6, those who skip from confinement or invaded sentence. 7. Those who were granted conditional pardon and violated any of the them thereof. 8. Those whose maximum term of imprisonment does not exceed 1 year or those with definite sentence. 9. Those suffering from any mental disorder or certified by a government psychologist. And then the number 10, those whose conviction is on appeal. And then the last one is those who have pending criminal cases. Okay. Next, the criteria to avail parole unless otherwise disqualified, a case for parole of a prisoner shall be reviewed upon showing that first, he is confined in prison or jail to serve an indeterminate sentence, the maximum period of which exceed 1 year again, for so on to a final judgment of conviction. And then the second one, that he has served the minimum period of a said sentence. Okay, next. Deferment of parole. Okay, the deferment of parole, if based on the pre-parole investigation report are conducted on the prisoner, there is a clear and convincing evidence that his release on parole will endanger his own life and those of his relatives, or the life, safety, and well-being of the victim, his relatives, his witness, and the community. The release of the prisoner shall be deferred until the danger ceases, or it means it is based on the pre-parole investigation report. So, as witness and the community, the prisoner's release will defer until the danger has passed, or no, has passed. Next, effective effect of violations of the terms and conditions of the program. So, this the compliance with the terms and conditions appearing in the release document is mandatory upon the failure of the parole to comply with any of the terms and conditions appearing in his release document. During the period of his parole, he shall be arrested and recommitted to prison and shall serve the remaining unexpired portion of the maximum sentence for which he was originally recommitted to a prison. So, violations of the program's terms and conditions have a negative impact. It is mandatory to follow the terms and conditions outlines in the release document. So, during the period of his parole, if the parole fails to comply with any of the terms and conditions listed in his release document, he will be arrested and recommitted to prison, where he will serve the remainder of the maximum sentence for which he was originally recommitted to prison again. Okay, next. Okay. Transfer or residence and travel prohibited without prior approval. So, a parole is not allowed to change his place of residence designated in his release document without the prior written approval of the regional director of the Board of Pardons and Parole and confirmation by the board. So, a parole cannot modify his place of residence mentioned in his release document without the previous written approval of the regional director of the Board of Pardons and Parole and confirmation by the board. That is that. Okay. That's all. Thank you and advance Merry Christmas.